Hello, everyone. Ladies and gentlemen, I say good afternoon and welcome to our webinar this afternoon. Our subject of discussion today is navigating construction adjudication using correct notices and time limits. This is intended to be a practical guide for contractors, developers, and consultants who use adjudication as a means of resolving disputes in construction. May I start by introducing myself to those who perhaps have not been to any of my prior webinars. I am Samuel Okoronkwo. I am a practicing barrister and head of chambers of mercantile barristers. And from time to time, we put up these webinars for the benefit of our clients to better inform them as to the live legal issues that affect their day-to-day activities. Prior to becoming a barrister, I started my professional career as a quantity surveyor. And from being a quantity surveyor, I graduated to becoming a project manager, running multiple high complex projects, as I will describe them, that are multi-million pound value across the United Kingdom and some internationally, before, of course, coming back to settle in the law. And suffice it to say, therefore, that one of my specialist areas of practice is construction law, and that is both contentious and non-contentious construction law. So, as a barrister, I do help my clients primarily by acting as their representative in the course of adjudications, either articulating their adjudication claims or defending adjudication claims when it's been brought against them. I also play a significant part in dealing with jurisdictional challenges that arise in the course of an adjudication. That is, jurisdictional challenges that are often raised by the claimants in adjudication. And of course, when one is in a defensive position and adjudication, a jurisdictional challenge is raised by the claimant, you get the opportunity to oppose it before the adjudicator determines whether or not they have jurisdiction to proceed. On a daily basis, I become involved in interpreting complex construction contracts for the benefit of clients, and I join in as instructed in the preparation for enforcement of adjudicators' decisions that we would have successfully secured if the defendant is not paying up, or indeed when some of my clients have had adjudication decisions against them, and we believe that the adjudicator has erred, and therefore our clients will not be obliged to making the payment. I play a major part in resisting the enforcement of those adjudicators' decision, which often takes place in the TCC, that is the Technology and Construction Court and the High Court. But I think generally the best value that I consider that I offer clients is in the pre-dispute strategic advice. Because of the nature of adjudications and the speed at which they progress, more often than not, the more strategic of the parties often is the more successful of the parties in the course of adjudication. So, by way of introduction of the objectives of today's webinar, it is intended that it should assist with a better understanding of the adjudication process, assist with exploring the key time limits under the Construction Act, specifically with getting notices that are deployed in the course of adjudication right, and to avoid fatal procedural errors in the course of raising notices. I stress the word fatal because more often than not, if you get your notices wrong in adjudication, you just completely have messed it up because the adjudication will fail. Even if you get the adjudicator's decision, you will find that the courts will be reluctant to enforce it because the notices are defective, because notices go to the heart of the adjudicator's jurisdiction to deal with a dispute that has been referred to the adjudicator. This session, therefore, has in mind contractors, developers, consultants engaged in the course of construction, that's the architects, the project managers, the quantity surveyors, civil engineers, structural engineers, and mechanical and electrical, and a whole host of other consultants who engage in construction. The reason for that is when the disputes begin to brew, you're often, if you like, in the front line at the work face, you're feeling it, you're seeing it. It is often on your advice that your clients will act as to whether or not they're going to bring an adjudication or whether, in fact, they're going to resist one that has been brought against them. So these are the people that I have in mind when putting this webinar together. So starting point then, let's just look at it. What is adjudication? An adjudication is a statutory dispute resolution process that came into being under the Housing Grants, Construction and Regeneration Act of 1996. It has subsequently been amended, but that is the foundational act. And it was a landmark act. It was groundbreaking in the sense that for the very first time in England and Wales, a dispute resolution mechanism was imposed by statute other than by agreement between the contracting parties, and it also, to a large extent, ousted the jurisdiction of the court until an adjudication has taken place. What do I mean by that? If in the course of a construction contract that contains an adjudication provision, you choose to go and litigate rather than adjudicate, you will find that the party against whom you're bringing the proceedings has liberty to apply to stay your proceedings until you have adjudicated. And that application invariably will be successful because adjudication is a mandatory statutory process, and that application will be made at your expense. So why begin a process that your opponent can apply for the court to stay because you have not adjudicated and in fact get you to pay the cost of that application? You simply don't do it. A key element, a key nature or characteristic of adjudication is that it's a fast-track process. The statutory calendar for it is a 28-day window within which the adjudicator has to make a decision. So can you imagine beginning your dispute and getting an answer in 28 days? Suffice it to say that there is a bit of an elbow room that the parties can, by consent, extend that deadline by a further 14 days. But that will be quicker than obtaining your judgment, getting your dispute resolved by following the court process. So the essence of adjudication is a fast-track dispute resolution process, which is literally conducted largely by professionals within the industry, not necessarily by, as it were, lawyers and judges, because judges don't become involved until, of course, the matter comes to court. But adjudication is therefore highly valuable in that it has the element of speed. Of course, as it gains the advantage of speed, it has, of course, sometimes the disadvantage that the legal reasoning that leads to adjudication decisions is not expected to be as qualitative as it might have been if the matter had come to court. Therefore, speed is of the essence. The common disputes that one encounters in the course of adjudication will usually relate to interim valuation payments. It also covers final account payments, and you also get delay and disruption claims. You get variation claims, you get extension of time claims. These claims can often be compartmentalized individually, or sometimes they can all be roped into one. Now, it's necessary to appreciate that an adjudicator's decision, once made, is binding until it is overturned by a subsequent arbitration or litigation. Now, it is binding. What that means is not just that it binds you, it also means that you must comply with it. In fact, you have no right to complain about the adjudicator's decision unless you have obeyed it. So it's pay now, then complain later. But when one looks at the practical net effect of it, if in fact you have a finding of liability against you under an adjudicator's decision, and you've been ordered to pay £1 million, it is somewhat difficult to have had to pay that £1 million first before you then get an opportunity to complain whether or not it was right or wrong. Therefore, it is imperative that you endeavor to ensure that you do not have a negative finding against you in the adjudication process in the first instance, if you can achieve that objective. Now, there are key notices, therefore, in the course of an adjudication for any adjudication to be valid. First and foremost, the claimant in the adjudication will have to have served a notice of intention to adjudicate on the prospective defendant. Say, take a typical developer and contractor situation, and the contractor wishes to bring a claim for, let's say, unpaid amount against the employer. You would have to have served a notice of an intention to adjudicate on that employer prior to commencing the adjudication process. Having served your notice of intention to adjudicate, your next step is usually then to apply to an ANB, to an adjudicator nominating body, to appoint an adjudicator to address the dispute. An adjudicator nominating body is an organization such as the RICS, the RIBA, or the professional institutions that have set themselves up as adjudicator nominating bodies. Once you have served your referral notice, applied for the adjudicator to be appointed, the next step, therefore, is to serve your referral notice. What is a referral notice? A referral notice, the best way of describing it is that it is your particulars of claim in the dispute. You would have articulated your claim, particularized it, then you serve that as a notice. You're serving it on the defendant and, of course, on the adjudicator, who is now, as it were, the referee in the middle. What then happens subsequent to serving your referral notice is that the defendant gets the opportunity to serve a response to your referral notice. And having received a response, you may then decide, depending on the circumstances of the case and what has been revealed in the response, whether or not you're going to enter a reply to that, and then there may be a rejoinder. This is now the, as it were, the cross submissions of particulars or answering the specific issues that arise. Now, each notice must comply with contractual and statutory requirements. That is very important to appreciate. So depending on the form of contract under which you have employed your contractor or you have been retained as a contractor, those will govern the time, as it were, limits within which you have to serve these notices. So I take you on to time limits next. By way of an overview on the time limits, the notice of an intention to adjudicate can be served at any time under the contract. The only essential requirement is that there is in fact a contract. Once the contract has been signed and it is live, at any time during the life of the contract, you can serve an intention to adjudicate. So there isn't a ban that you can't begin your adjudication process until something has been achieved or a given stage of the contract has been reached or whatever else. Now, at any point in time, if a dispute is crystallized, you have the entitlement to serve a notice of an intention to adjudicate. As I said, having served your notice of intention to adjudicate, your next logical process step is to make an application to an adjudicator nominating body in order to appoint an adjudicator. Most ANBs will appoint an adjudicator for you within a 7-day time limit. Now, in practice, they would actually do within 48 or 72 hours without much delay. You will have your adjudicator appointed reasonably promptly. The ANB would have checked that there are no conflicts issues involved, and an adjudicator will be appointed. Once the adjudicator has now been appointed, the referral, i.e. your particulars of claim, must be served within a 7-day period. And this is very important. If you see the extent of work that goes into articulating your particulars of claim and the fact that you must serve it within a 7-day period, you will then immediately appreciate that that is a very tight turnaround indeed. And you must therefore prepare in advance. because you cannot afford, having served your notices, then to fail to serve your referral in time, because quite frankly, you will kill your own adjudication in its tracks if you fail to do so. So the time limits are quite significant. Now, so over and above the time limits, the substance of the notices are very important. So the common pitfalls that one encounters is that the notice has been served on the wrong recipient. Now, one may sit back and say, how could you serve the notice on the wrong recipient? Now, it's been known that certain contracts are entered into by parties, and certain contracts have parent companies sitting behind them. More often than not, you find people who are ill-advised serving a notice on the parent company rather than the contracting party. Such a notice will have been served on the wrong recipient and will be invalid. Now, there are also authorities where, for some reason, the primary party to the contract has assigned the contract to a second party, and the dispute arises as to payment. Then the notice is served on the party that has received the assignment, the assignee of the contract. You will find, unfortunately, that your adjudication will fail, because usually an assignment, what is really transferred in an assignment are the benefits of the contract and not the obligation. And if you're seeking payment, it will usually be an obligation under the contract. So you can't afford to serve the wrong party. Probably, when in doubt, my advice always is to seek legal clarity as to who your recipient, your appropriate recipient, ought to be before you serve the notice. And another pitfall often is that the wrong address is served. Now, certain companies will have their trading address, their registered address, or indeed other address. In fact, if you can, serve your notices always on the registered address of the company. If you serve on any other address, an issue may arise as to whether or not you have delivered your notice at the correct address. If it's been delivered to the wrong address, I'm afraid that will invalidate the notice and you may have to start the process all over again. Now, certain notices also have key vital information missing. Now, the contents of your notices must be comprehensive and no vital information that you intend to rely on or to be missed out of it. And if you have missed that information and you subsequently revert to amend your notice, you may well find that the entire adjudication may have been invalidated because you are seeking to make an amendment, which by its very nature is looking to introduce something that was not in the preliminary notice, which is an essential element. It's been suggested that templates could be used. I have templates for some of my clients that they use. I provide also a checklist of things that must be ticked off to ensure, to guarantee the validity of your notice before you get out of the traps. And that is so important that you have that, just to be certain, because nothing could be more embarrassing than incurring the substantial costs involved only to find that your notice has been invalidated. You must always, in issuing your notices, follow the contractual and statutory rules in so doing. Any deviation from them, you may well find that the notice is invalidated. And if your notice is invalidated, you may well find that an adjudicator that's been appointed under an invalid notice will lack jurisdiction to address the disputes that's been referred to him as an adjudicator. So let's look at some practical issues. That example that I've put up on the screen is that a contractor makes a claim for unpaid variations, serves a notice of intention to adjudicate. An adjudicator is subsequently appointed, but the referral is submitted late. That invalidates the adjudication immediately. Now, in certain circumstances as well, when you have prepared your notice, and in fact, there are authorities where you have prepared your notice, commenced your adjudication, and subsequently gone back to amend your notice, an attempt to amend your notice, and you're introducing in your notice something that wasn't there originally, you will then find that your updated notice has, as it were, come after the appointment of the adjudicator, when in fact those notices should have started ahead of the appointment of the adjudicator. And because of that procedural misstep, as it were, your notice coming after the appointment, it would invalidate the notice, and the adjudicator that had been appointed prior to the notice that they are relying on will lack jurisdiction in determining the disputes that's been referred to it. And the risk there is that that adjudicator may well proceed to make a decision, but if the defendant against whom has been found refuses to comply with that adjudicator's decision, and you go to the High Court to seek to enforce that judgment, that adjudicator's decision, you'll find the High Court very reluctant to oblige you. They will refuse because quite clearly the adjudicator lacks jurisdiction. It is also important to realize that only a single dispute can be referred to an adjudication at any point in time. Now, where you seek to refer multiple disputes under one adjudication, under one claim, you will find that your opponent may well take an issue to say, no, more than one dispute has been referred here. The adjudicator has no jurisdiction, as it were, to deal with multiple disputes in one adjudication, and as such, lacks jurisdiction to proceed. Now, what happens with jurisdictional challenges usually is that when it is raised, the adjudicator then has the opportunity to determine their own jurisdiction. So you go to an adjudicator and say, you should stand down because you have not been validly appointed, and therefore you don't have the jurisdiction. In essence, you don't have the authority to deal with these disputes. The adjudicator gets to look at it and comes to what is usually a non-binding decision, saying, look, I have formed the view that I'm entitled to proceed to adjudicate this matter as the adjudicator. That is my decision, and I'm going to proceed. Now, the party that's taken up the jurisdictional challenge may decide to continue on the protest, but keeping that up their sleeve, because if the decision subsequently becomes negative against them, they may refuse to comply with it, and they will point to their prior jurisdictional challenge, and that is where the matter then comes into the High Court. You will normally come in the High Court as a Part 7 claim in some cases, and you will find that there is also a substitute Part 8 claim that comes with it. And perhaps I'm being a bit technical in referring to Part 7 and Part 8 claims. In summary terms, in Part 7 claims, there is still legal argument and there are disputes to be had. In Part 8 claims, you usually take the view that there isn't much to be argued because it's clear. Now, in more detailed sessions on dealing with enforcement and resistance of adjudicators' decision, I go into greater detail on those, but given the brevity of time, I won't delve into that detail in this webinar session. So, making progress, therefore, tips for success. Now, you must actually keep clear records and maintain clear correspondence that addresses the specific issues that you are going to be relying on in the resolution of specific disputes. When you're progressing towards adjudication, you must identify the adjudication clauses that are in your contract, or indeed if you're relying on the scheme for construction contracts. You have to draft your notices carefully, as I have highlighted, and indeed, if you consider that it's beyond you, it is often a counsel of prudence to seek legal help in getting your notices right. Now, you must treat your notice of intention to adjudicate as the starting gun. And once you fire that starting gun, as you can see, the time clock starts, and then you must move quickly. So it is very necessary that you prepare before you begin adjudication. Now, most contractors and subcontractors, and sometimes employers, begin an adjudication without appropriate preparation. And I cannot overemphasize the necessity of being ready before you press the button. And in contrast, if you're at the receiving end of adjudication, you may well find that you then have to go at double quick speed because the claimant has prepared well in advance before issuing you with the relevant notices. So when adjudication goes wrong, often the issues that one encounters are jurisdictional challenges that I have referred to. In other words, one is now resisting obeying the adjudicator's decision on the basis that they are lacking, that the adjudicator who made the decision lacked jurisdiction, lacked the legal authority to make the decisions that they made. So you have challenged their jurisdiction at the outset, and you are ready to take it further to the Technology and Construction Court. So the beneficiary of the decision, of the adjudicator's decision, will generally seek enforcement at the High Court, and the Technology and Construction Court will move very quickly to enforce the decision, because the propensity is to enforce unless there is a good reason not to enforce. Okay, so common causes of these difficulties that you will encounter when adjudication goes wrong is that notices have either been late, or they are invalid, they are unclear, and they contain other legal defects which invalidate them. But what you then will have to appreciate in those circumstances is that being clear in your notices, being accurate, being precise in your notices is what is weight in gold. Prevention, as I say, is always better than cure. Therefore, I draw to a close in summary my presentation to you, and it's time for questions and answers. So I invite questions and answers to the extent that you have any, so that I can address them. Thank you very much. So any questions, as it were, you type it in and I will see them and hopefully be able to address them. So as we're streaming this, we're obviously waiting. I understand there are questions on YouTube, but they haven't found their way to me yet. As soon as I get the questions, I'll be able to address them. So what happens if you send a referral notice before the notice of intention to adjudicate? Does it ruin your chances? Well, if you look at it, it is bound to ruin your chances, because the chronological order is very important. You have to have sent your notice of intention to adjudicate. And in fact, if you send your referral notice prior to doing that, it is in fact questionable whether an adjudicator nominating body would accept your application to appoint an adjudicator, because they would normally insist that your application is accompanied with your notice of intention to adjudicate. So it would be inadvisable to contemplate your referral notice ahead of your notice of intention to adjudicate. In fact, it's putting the cart before the horses, as it were, which will be inadvisable. So I believe that that question is sufficiently addressed. Please don't do your referral notice before you have filed your notice of intention to adjudicate. That was the first question. The second question: what happens if you send a referral notice before? Okay, does it ruin your chances? I think it's a repeat of the question that I've already answered. Now, the next question in the queue is also: we are in a post-Brexit stroke US tariff world. Can we start an adjudication because of timing delays? And some things are beyond our control, and I think we are being treated unfairly. Now, the timing delays is worthy of consideration. The question is timing delays from when to when. Clearly, post-Brexit and the US tariffs, they will have an impact on your contract. But if you've fired off your notice of intention to adjudicate and you've, for some inexplicable reason, found time to run away from you, probably better to repeat that notice of intention to adjudicate and then seek the appointment of an adjudicator and therefore proceed that way. But if you have had an adjudicator appointed, then you really must comply with the 28-day time limit, because that is the raison d'etre, as it were, for adjudications. That is the beauty, and that is the reason why we have adjudication, because of the speed. Okay, I noticed that you may consider that you may have been treated unfairly. The question is to maintain parity, to see that no unfairness is done to the other side as well if the time limit's extended. But I would say, notwithstanding the effects of Brexit and tariffs, you should still keep within the adjudication timetable. That would be my approach to that. The next question is, should we have had a lawyer in place from the start to deal with the adjudication? It is advisable. I know I'm a lawyer, and clearly it is said that lawyers will want to be in place. And I say, for your own benefit, it's often having good counsel in place in advance is a stitch in time that saves none. By all means, you can go and DIY it. You can go and do it yourself, make all the mistakes, and then come back to the lawyer. But then you find that that would be a very expensive route of trying to resolve your issue. I mean, you're engaged in hundreds of thousands and sometimes millions of pounds claim. If you don't have a lawyer on your side, you bet your bottom dollar that your opponent will. Why would you want to go into a fight less prepared than your opponent? I would advise that it's wise to get legal advice. Even if you're going to do it yourself, get legal guidance that you're doing the right thing. That would be my answer to that question. The next question is, when would a consultant's contract fall under the scheme? Now, it's interesting. A consultant's contract, you have to just check that it's a construction contract. If it is a construction contract as strictly defined, then it will fall under the scheme, and you can adjudicate under it. The question is whether who is bringing the claim here? Is it the consultant or is it the employer? And what is alleged? Is it a breach of contract, or is it a prospective claim for professional negligence? I would have thought that if one was contemplating a professional negligence claim, it would be better to use the professional negligence protocol, but it will fall under a construction contract. And if it falls under a construction contract, there is no reason why it cannot be referred to adjudication. So the next question, supplementary provision 6 of the JCT contract negotiation. Is this similar to adjudication but less formal and to be arranged between both parties directly? It's a question that's been raised by Timothy. And it's the supplemental provisions is a case of actually what the parties have included in it. Now, if you have negotiated it yourself, irrespective, and it still is a construction contract, it clearly falls within the rules. It's no less formal or more formal. It can be both parties can agree in advance who their adjudicator will be, if I'm understanding your question, Timothy. And it's a unique question which perhaps merits further attention or clarity. I don't know if you're able to clarify it, or feel free to email me directly as to the specific issues you have with that, because one will have to understand your question as to the formality. So as to what you mean, what is arranged between the parties and the formality that's engaged. But generally, it will be a construction contract which falls under the adjudication rules of the Construction Act. Okay. Now, Tav has asked a question. Tav says, if the contract excludes adjudication as a dispute resolution mechanism, would I still be able to use adjudication under the scheme instead? Prima facie, I will say yes, because it's a statutory provision. And the question arises as to both whether parties can contract out of it. Now, if one party has proposed it, the question is, has the other party accepted? And even if you have purported to do so, I struggle to see how you can contract out of the statutory provision, because there are no exceptions in it. If it's a construction contract, you will be entitled to bring your dispute resolution under the Act, which is unique. Now, there are, and certain clients invite counsel to draft provisions to either ameliorate or indeed circumvent certain provisions of the Act. Invariably, that's an effort in futility. If anyone has sought to exclude the Act completely, it is most unlikely that they will find favor with the courts. If you're looking to exclude adjudication as a means of resolving a dispute, because you're then going straight into litigation. I hope that is satisfactory, Tav, but if there is a specific issue on that, as I say, have no difficulty in coming back to me directly if I haven't got the full details by your full details of the question that you're raising, and I can address it specifically. Terry Venner has asked a question. The question is, says, thank you, Kevin Brady, thank you. Samuel, very useful. Okay. Mwabezi Jr., it's been explained very clearly that I can get it, so thank you very much. You're most welcome. I'm grateful that you found it valuable. Thank you. Good. If there are more questions, please do keep firing them, and I'll deal with them for hopefully another 5 to 10 minutes or so that we have available. By all means, there is a QR code on the screen. Feel free to scan the QR code and therefore send in any questions you may have, and I will gladly address them. If you are unable for one reason or another to type your question into the live chat, scan the QR code, put your questions through. They'll get just as much attention, and perhaps you may get the opportunity to widen the scope of the question you have, and therefore I'm able to give it greater clarity and not give you the standard answers based on your two-line questions. So the QR code is on the screen. Feel free to scan it and then use it if it is of value to you. So if there are any more questions, we can address them in the remaining minutes. Mark Chapman, no questions. Thank you very much. You're most welcome, Mark. Thank you. If we come to you directly, can we ask questions? If we don't want to do so on this forum, by all means, as I say, you can. At most, I tend to find in webinars, and I have clients who come back to me to say, look, I will invite you, please, to assist us with this problem. I was in attendance at that webinar, but for one reason or another, I didn't summon up the courage to pose the question. Yes, the QR code is on the screen. Feel free. Send in your questions and I will address them. Thank you very much. It's been an enlightening webinar, says Tav. Tav, you're most welcome. I'm pleased you found it valuable. And then again, of course, if you have queries arising, if you're dealing with matters the matters I've discussed today are touching upon, have no hesitation in coming back for clarification to assist you. So it's a pleasure. I'm told that we have a few more minutes, and question, this time from Thorley, Timothy Thorley. What's the average cost for an adjudication process per party? Timothy, how long is a piece of string? Now, there are complex adjudications and there are easy adjudications. Now, one other observation I tend to make is that counsel, like myself, who seldom discuss costs, my clerks will be very delighted to assist you in giving guidance so that you have clearly in your mind what you're about to get into before you do. But there is clarity in it. But there isn't, I'm afraid, a standard fee scale for adjudications, because there are adjudications that are substantive in nature, and there are some that are more simplistic. If a standard cost was to be deployed, you will find that if you have a simpler case, you'll end up subsidizing those that have a more complex case. And then, of course, is to remember that largely adjudications end with the adjudicator's decision, but not necessarily, because if you are at the receiving end of a substantive judgment that you don't agree with, you are perfectly entitled to escalate the matter to the High Court. But then, of course, ensure that you have built in, as it were, the steps to enable you to get there. Because if you get there simply because you don't like the decision, the High Court will say, tough, pay it first and then argue later. Okay. Thank you very much. Very informative. Will you please make the video available to us? Brody Chenton's asked. Yes, I believe it will be made available by my clerking team. If you haven't received it soon after the webinar, feel free to drop me a line, and I'm sure a member of my team will respond with it accordingly. Yes, it will be available. Thank you very much. We have the last minute available, and if there is one final question, I will address it, but if there isn't, we will be delighted to say thank you very much for your participating. There's one question. Available for reply via YouTube. Available for reply via YouTube. Yes, there is. I believe we have availability to reply, to replay. Forgive me. Availability to replay via YouTube. I believe that the webinar will be available for replaying via YouTube. Yes, the answer is yes to that question. But thank you very much for your attendance today. I hope you have found it valuable and informative. And I look forward to seeing you in the next webinar, which my clerking team will announce in due course. And if you have any feedback, by all means, have no hesitation in feeding us back. And thank you very much for being part of our webinar team. Thank you, and bye-bye.